Hello everyone and welcome to our presentation on the prevention of sexual harassment in the workplace with a manufacturing focus. So just to introduce ourselves, I'm Anjali, I'm one of the employment solicitors in the team, and this is my colleague Charlotte Gilbert, who is a partner and also head of our Myosin HR.
Hello.
So moving on then to our agenda. So part one is going to be covered by myself, and I'm going to be talking about what constitutes sexual harassment and the duty to prevent sexual harassment, including details of reforms by the Employment Rights Act 2025. Part two will then be covered by Charlotte, and she'll be discussing the general and unique risk factors for manufacturing employers, as well as practical steps to strengthen compliance as well, with a focus on developing a speak up culture. So moving on to part one, which is the law and the duty to prevent. So I'm firstly going to talk about the key legislation in the UK, and for us, this is the Equality Act 2010. So Section 26 of the Equality Act prohibits three types of harassment. The first is harassment related to a protected characteristic. So there are 9 protected characteristics, and those are age, gender reassignment, marriage and civil partnership, pregnancy and maternity, disability, race, religion or belief, sex, and then finally sexual orientation as well. The Equality Act also prevents sexual harassment, which is what we'll be focusing on today. And finally, it prevents less favourable treatment because an employee either rejects or submits to unwanted conduct of a sexual nature, or it is related to gender reassignment or sex. So who is protected? Well, for the purposes of the Equality Act, that is an employee, but this actually covers a wider category of individuals, including those who are self-employed, provided that the contract requires them to perform the work personally. So this will cover employees, so those who have a contract of employment, workers, provided they are contracted to perform the work personally. So that wouldn't ordinarily include 0-hour workers and Uber drivers, for example. It would also cover apprentices, so those who have a contract of apprenticeship. And as I mentioned earlier, it can also sometimes include those that are self-employed, provided they are personally required to perform the work and they cannot provide a substitute as well. So let's unpack the legislation in a little bit more detail. So the legislation on the slide sets out the general harassment provision, and that sets out that even a person engages in unwanted conduct relevant to a protected characteristic, and that same conduct has the purpose or effect of either violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. The second provision is in relation to sexual harassment. So again, it's the unwanted conduct of a sexual nature, and it has the same purpose or effect as I've spoken about earlier. And then finally, on the next slide, it's the third provision, and this is the less favourable treatment provision. So again, treating someone less favourably because they either reject or submit to sexual harassment, or if it's related to gender reassignment or sex as well. So looking at what sexual harassment is and deciding whether the conduct has the effect referred to earlier, so violating a person's dignity or creating a hostile, intimidating environment, the Equality Act sets out some circumstances which is helpful to take into account. So that includes the perception of the victim. So how does the employee feel? That's obviously a subjective element of the test. It guides us to consider all circumstances of the case, so it is fact specific. And then finally, there is an objective element as well. Was it reasonable for the conduct to have the effect that I spoke about earlier? And when thinking about what constitutes sexual harassment, the Equality and Human Rights Commission has provided some helpful guidance of the sort of behaviour and actions which it would constitute of unwanted sexual conduct. So this can include sexual comments or jokes, displaying sexually graphic pictures, posters or photos, suggestive looks, staring or leering, making sexual advances, promises in return for sexual favours, to sexual gestures, intrusive questions about somebody's personal life, sexual posts or contact on social media, spreading rumours about the person, and sending explicit emails or text messages, and unwelcome touching, hugging, massaging, or kissing. So again, it ranges from the physical to the more insidious as well. And I think what's helpful to note is the Fawcett Society, which is the UK's leading charity on gender equality and women's right at work. They make the point that sexual harassment isn't actually always motivated by sexual interest, and it can be used to humiliate or belittle somebody with the goal of putting them into place or to create entertainment from others. So, an example of this could be a male worker who alters a pornographic image by pasting a female colleague's face onto it. He would then send it to other colleagues, causing them to ridicule. Again, the motivation behind this act isn't of a sexual nature, but it would still amount to sexual harassment. So I think that's a really important point to note when considering whether it would amount to sexual harassment under the test. So moving on to the case law on sexual harassment. So I think there was a few comments I wanted to make. So a single incident can amount to sexual harassment. It doesn't necessarily need to be a campaign. Sexual harassment that has been welcomed in the past and an employee has put up with it for years doesn't mean that it can't be unwanted. There may be other reasons as to why they felt afraid to speak out, for example. Um, And the fact that, as I said, a consensual relationship ends, this could also mean that the conduct then becomes unwanted. So an employee may succeed in a claim, as I said, when a consensual sexual relationship ends, and then the other party continues with the same conduct, but that is unwanted as well. So moving on to the duty to prevent sexual harassment. So we say this is a new duty, but it's actually come into force since the 26th of October 2024. And since then, employers have been under a duty to take reasonable steps to prevent sexual harassment of their employees in the course of their employment. And as I put on the slide, it's important to note that this duty is both anticipatory and also ongoing. So it's not a simple box ticking exercise, but instead something employers need to consistently manage and review as part of its processes to ensure that it remains compliant. As a result of this new duty on employers, there are financial penalties. And in the context of an employment tribunal claim, the tribunals have the power to award an uplift of up to 25% to compensation awards where the employer has breached its duty to take reasonable steps to prevent sexual harassment. So this can be a really significant financial burden on any company. Because, as we know, discrimination claims are not capped as well. So it could be an additional sting in the tail. So talking now about the EHRC enforcement action. So I've spoken a little bit about the financial penalties in the employment tribunal, but I wanted to talk as well a little bit more widely on the powers of the EHRC, as many people may not know this. So the EHRC is a regulator and it does have wide powers when it comes to implementing the duty to prevent sexual harassment in the workplace. So as put on the slide, the EHRC has powers to investigate an employer when it comes to that person and whether the company has committed an unlawful act. They can issue an unlawful act notice where they found that the employer has breached the Equality Act provisions, and they can require them to put together an action plan setting out the remedy of any continuing breach and how to prevent it in the future. It can seek a court injunction as well to restrain an employer from committing said act. And then finally, it can enter into a formal and legal binding agreement to prevent the employer from continuing to commit unlawful acts in the future as well. And to put that into an example, so Lidl, for example, in August 2025, they signed a legal agreement with EHRC to prevent sexual harassment in the workplace. And this was off the back of the EHRC finding that Lidl had failed in its duty to prevent sexual harassment. And as part of that legal agreement, Lidl is now committed to running staff surveys relating to sexual harassment, arranging meetings to discuss the risks. They are under an obligation to develop systems to monitor and analyse complaints, monitor the effectiveness of any complaints handling, reviewing their previous sexual harassment complaints, looking at its own risk assessment, and further review of its internal harassment policies and training content as well. And this is just one example of the agreements that EHRC can put in place. There's been other incidences with IKEA and McDonald's, who are obviously big global brands. And again, the EHRC has advised them, or beyond advised, required them to enter into a legal agreement as part of their breaches of that duty. So we've spoken about the current duty, but now wanted to talk about the Employment Rights Act and the future reforms that are upcoming and in place. So under the Employment Rights Act, a new duty will be introduced, which will set out that employers must now take all reasonable steps to prevent sexual harassment in the workplace. So clearly with the inclusion of all, this will present a significantly higher bar on employers. As set out in the government's implemented roadmap, this is now expected to take effect in 2027 to 2028 rather than 2027 as initially stated. So there's a few years when it will come into force. So when thinking about what is reasonable steps, well, at the moment, it depends on a variety of factors. And this can include the size and resources of an employer. So bigger employers with more resources will be held to a higher standard. You'll consider the sector in which the employer operates, because the risks will differ vastly depending on said sector. So with hospitality, there'll be a higher public contact, whereas in construction, these tend to be more male-dominated workforces and also off-site as well. You'll consider the nature of any contact with third parties. So again, those with a higher client interaction must take specific steps to protect its workers from customers, clients and suppliers. And as we'll come on to, there is a new third-party harassment that's being introduced as well. What is reasonable can include the time, cost and disruption of taking a particular step. So again, the smaller businesses may have simpler measures in place and which they can justify on the cost measure as well. And then what could also be reasonable is depending on whether concerns have been raised with an employer in the past. And I think it's very fair and sensible to say if that does arise, the expectation would be for the employer to put in steps to prevent such sexual harassment happening again. Under the regulations, though, we are still awaiting further information of the certain steps employers are expected to take. But there have been some steps which have already been specified in the legislation, or in the regulations, I should say. And this will include, but is not limited to, carrying out a risk assessment, publishing plans or policies, so cover action plans and sexual harassment policies, putting in steps to support the reporting of sexual harassment. So what internal measures will its workers be encouraged to take? And then also putting in steps relating to how an employer will handle complaints. So that's training managers and HR And this is something that Charlotte will be talking about in a little bit more detail in her section too. So moving on then to third-party harassment. So as I touched upon earlier, this is a new reform which is being introduced under the Employment Rights Act. So this is expected to come into force from October 2026. And this says that employers will now be liable for all types of harassment, so not just sexual harassment, by third parties unless an employer can demonstrate they took all reasonable steps to prevent such harassment. The statute offence of all reasonable steps mirrors that which is already in force in the Equality Act, in which case an employer can defend claims of harassment if they can show that they took all reasonable steps to prevent the perpetrator from carrying out the discriminatory act. So we expect it to broadly follow what has already been set out and developed in case law. Under case law, it does depend on the facts, so it's always very fact specific. But the starting point of having mandatory equality and diversity training, setting out the expectations of behaviour, and also having clear policies in place are some practical ways that employers have often taken to be able to show that they've met that statutory duty. And why have they introduced this? Well, as I put on the slide, in relation to sexual harassment, at least, the Trade Union Congress found that 39% of sexual harassment incidences were carried out by a third party, and 52% of women aged 18 to 34 reported that they had experienced harassment by a third party at work. So clearly, it is a widespread problem that the government has introduced the legislation to try to tackle. And as I said, third-party harassment is harassment from customers, contractors, or suppliers as well. And just in the context for those in the manufacturing sector, I think this is really important, given the regular interaction manufacturing workers often have with customers, contractors, and suppliers. But again, more on this and the unique risk factors will be discussed later by Charlotte. So moving on to the next slide, please. So another change by the Employment Rights Act is on whistleblowing and NDAs, so non-disclosure agreements. I put NDAs, but actually it's in relation to confidentiality clauses more generally. But the first point in relation to whistleblowing is that the ERA has clarified that sexual harassment will be treated as a qualifying disclosure under whistleblowing legislation. Arguably, under the current legislation, sexual harassment would already qualify as a qualifying disclosure because it's a breach of a legal obligation. But very helpfully, this explicit legislation, makes it clearer. And regardless, an employee would still need to meet the other qualifying elements of the test to amount to a protected disclosure under whistleblowing law. In relation to the confidentiality, so significantly, what the Employment Rights Act has proposed is that employers will be prohibited from including confidentiality clauses which prevent employees from disclosing or raising allegations of all harassment and discrimination by making these clauses void. And this also includes an employer's response to such allegation as well. However, we're still waiting for further details in relation to this, and we've been told that this will not apply to accepted agreements, which is going to be defined in secondary legislation following consultation. And in terms of timescales, as I said, it's not quite clear when this new provision will come into force, given in fact there needs to be some consultation of what will be the carve out for the accepted agreement. I think in the meantime, employers should still, as I'm sure they have been doing, ensure that any carve out in any, or ensure there's an appropriate carve out in a settlement agreement to ensure that employees can make a protected disclosure as well. So more on that later, but it will be very significant in the future, particularly when it comes to settlement agreements, where we often want employers employees to remain confidential and not disclose facts of discrimination. Now, I've spoken a lot about the law, the new duty, and the reforms, and I just wanted to talk a little bit more generally, aside from the financial consequences, of the importance of preventing sexual harassment or harassment in the workplace. But particularly in relation to sexual harassment, this can lead to high-profile departures of senior management and expensive litigation. We've seen, of course, on BBC, household names like McDonald's, for example. It becomes part of the press when senior managers have found to be committed sexual harassment in the workplace. It can cause damage to an employer's reputation. I said particularly with those of global brands, media more likely have an interest in those sort of allegations. It can affect employee and customer relationships. And finally, it can also have adverse effect on recruitment and employee retention as well. So there are the broader business case beyond the financial consequences as to why it's really important to prevent sexual harassment in the workplace. And moving on to the next slide. And that's it in terms of my part of the presentation. I'm now going to pass you on to my colleague, Charlotte, who'll be talking, as I said, about the unique and general risks in the context of manufacturing.
Thanks very much, Anjali. So now that Anjali has identified the legal position and duties on employers, I'm going to look at some of the specific risk factors and practical implications for employers in the manufacturing sector, and then take you through the suggested steps that a business should take in order to manufacture a safer workplace. So we know that harassment is widely underreported in all businesses and across various sectors. Recent estimates from research commissioned by the BBC suggest that 40% of women and 18% of men have experienced some form of unwanted sexual behaviour in the workplace. And this was found to range from unwelcome jokes, banter, and comments of a sexual nature to serious sexual assault. Despite this, Unite, the union, reports that 75% of women who have experienced harassment in the workplace didn't actually report this to their employer. So for an employer to create a workplace culture that minimises the risk of sexual harassment, it needs to understand the extent of its current problem and identify the barriers to reporting. So the Equality and Human Rights Commission has identified a number of barriers to employees reporting harassment, which are just worth considering and being aware of. Firstly, the view that raising the issue was useless as it wasn't taken seriously by the employer, and that half of those employers receiving reports of harassment took no action at all. Another barrier to reporting is a belief that alleged perpetrators, particularly senior staff, would be protected regardless of any allegations raised against them. Also, a perception that managers would be inexperienced and unsupportive of any issues raised. And fear of victimization is another identified barrier. So, for example, a fear of damaging their career prospects or feeling punished if the employer's reaction was to move them to a different department or role when the alleged perpetrator was left in their existing role. And also a fear of feeling blamed for reporting the harassment in the first place. And finally, a key factor putting people off reporting is a lack of appropriate and clear procedures for how to go about this. Excuse me. So this is why it's really important to create a speak up culture within your business to encourage openness and reporting of any incidents. Now, the research shows us that the culture of an organisation is the best predictor of the likely level of sexual harassment within a workplace, and that employees respond to their environment. So if their employer takes sexual harassment seriously, then they are more likely to as well. The Equality and Human Rights Commission describes a zero tolerance approach to harassment as recognising that no employee should have to experience sexual harassment at work, taking all concerns raised about harassment seriously, and taking action promptly. So, bearing all of this in mind, then, the way to develop a speak up culture in your business is to ensure that senior managers and leaders visibly demonstrate and openly communicate a zero tolerance approach. This is really important to show employees that these issues are taken very seriously and that they can trust that the leaders and managers of the business are taking proactive steps to prevent sexual harassment from happening. In doing this, managers need to bear in mind that they are role models and that employees will often follow their lead in terms of conduct or banter. So it's the managers who really need to maintain appropriate standards of conduct in the workplace to lead by example. Everybody should be encouraged to report harassment, and that's including bystanders who witness that treatment, as well as the victims themselves. And it's also a good idea to consider the impact on victims and to offer mental health resources to the complainant, like counselling services, and that's both during the investigation and after it's concluded. Providing victims with choice, control, and voice in the process is an important part of developing an open environment for reporting and a speak up culture. So just moving on to the next slide then, there are a number of general risk factors which the EHRC has identified as being more likely to cause potential exposure to sexual harassment and victimisation in the workplace. We'll go through this list now as it forms a good guide of the factors which every employer should be considering when undertaking a risk assessment in its own workplace. So, power imbalances, particularly gender power imbalances where most junior staff are women and most senior managers are men. Job insecurity, for example, the use of 0 hours contracts or agency staff or contractors. Lone, isolated, and night working or working alone with a third party can be another risk. Out of hours working or events where there may be alcohol involved. Customer facing duties, and this is particularly relevant in the context of the risk of harassment from third parties. Lack of diversity in the workforce, especially at a senior level, is another risk. And workers being placed on secondment or travelling to different work locations or working from home should all be factored in. Attendance at events outside of the usual working environment is another potential risk. And this could include training, conferences outside the workplace, or work-related social events. And socialising outside of work and social media contact between workers is another general risk. A workplace culture that permits crude or sexist banter or other disrespectful behaviour is another factor. Any failure to respond to previous reports of sexual harassment is a problem, as this can directly impact on the willingness of employees to report incidents of harassment in the future. A lack of policies or procedures as to how an employer will deal with an allegation of sexual harassment is another risk. And it's worth remembering that workers with more than one protected characteristic are statistically more at risk of sexual harassment. So, for example, women, disabled people, ethnic minorities, and LGBT individuals. So now there are certain risk factors which are particularly relevant to the manufacturing industry, and these should also be considered as part of your risk assessment. So the sector often has a tiered management structure and hierarchy, which can contribute to power imbalances, making the sector at high risk of claims. And other unique risk factors include having a male-dominated workforce and perhaps having the majority of senior management roles typically being occupied by men. There may be more of a prevalence of 0-hour contracts when compared to other industries, and perhaps a higher turnover in the workforce, so potentially giving rise to more risk. This all might give rise to the risk of crude banter at particular sites or levels within the business. And there's also more likely to be regular worker interaction with third-party contractors in this industry. So all of this should be identified in the context of each individual business when undertaking your risk assessment. So once you have identified the risks in your business, the next step in the process is to consider the proactive steps that you will take in order to comply with your duty to prevent sexual harassment. And the Equality and Human Rights Commission has helpfully created an 8-step guide which sets out the kind of positive action that employers should take in view of the duty to prevent sexual harassment in the workplace. And it's important to note here that, as Anjali has explained, the current duty is to take reasonable steps, and that's having regard to various factors, including the risk and size of organisation. However, there will be a more onerous duty in the future to take all reasonable steps, and we await clarity as to what those are. So the current 8 steps from the EHRC are, firstly and importantly, to develop an effective anti-harassment policy. This should include details as to what conduct is unacceptable, the employer's zero tolerance approach to that conduct, how staff can report inappropriate conduct, the process that will be followed, and the support available for victims of sexual harassment and those who report it. Staff engagement is the next step, so employers are advised to conduct regular one-to-ones, run staff surveys and exit interviews, and have an open door policy. Assessing and taking steps to reduce risk in the workplace by carrying out a risk assessment and conducting regular staff surveys to ascertain the extent of the potential problem for the business is all key in taking reasonable steps to prevent harassment. Encouraging the reporting of sexual harassment by having effective reporting mechanisms in place, which provide different methods of raising a complaint and a clear process for how that will then be dealt with. Providing mandatory training for all staff is also key. And if that's something that you are interested in getting, then we do provide bespoke and in-person training tailored to your business and policies. Having a clear procedure in place for what to do when a harassment complaint is made is also a positive and key step to take. And this ensures that complaints are investigated and dealt with promptly, effectively, and in a sensitive way. An employer should also consider how to deal with third-party harassment by taking this into account in a risk assessment and having effective measures in place to help to minimise this risk. Monitoring and evaluating actions. So employers should regularly evaluate the effectiveness of the steps they've put in place to prevent sexual harassment and implement any changes arising from this. And that's all being mindful that the duty to prevent sexual harassment is an ongoing duty. So just turning to managing this in practice then, where a complaint is received, an employer should take it seriously and consider whether an external investigator should be instructed to conduct the investigation. The individual who reported the harassment should be kept regularly updated on the investigation. And it goes without saying, but a complaint of sexual harassment should never be ignored or covered up, and it shouldn't be assumed false or doubted just because nobody else witnessed it. Any complaint should be handled fairly and sensitively, and it's important for an employer to always keep an open mind. In practice, and just moving to the next slide, keeping an open mind means that an employer should not let their own views or feelings influence how to handle that complaint. And this is particularly important if the manager gets on well with the person accused of sexual harassment, or if they believe that the person accused is not likely to have done it or isn't capable of such behaviour. Where the person accused is someone senior or influential within the business, then this too should not be dismissed, and it may be more appropriate to appoint an independent investigator. And the other risk and need for keeping an open mind is where the investigator does not personally find the behaviour offensive. So where a disciplinary process is needed, employers should carry out an investigation promptly and sensitively. And depending on the circumstances, it may also be necessary to involve the police where the behaviour constitutes a criminal offence. The employee should be made fully aware in writing of the allegations made against them, and be informed of the possible outcomes of the disciplinary hearing. So if the allegation is one of gross misconduct, then the employee should be warned in advance that a potential outcome of their disciplinary hearing is dismissal without notice for gross misconduct. The employee should be given any evidence from the findings of the investigation in good time beforehand in order to prepare for the hearing, and they should be given reasonable time to prepare their response. At a disciplinary hearing, employers should explain the company's case and give the employee the opportunity to put forward their case in respect of the allegations against them. And that's before then considering all evidence raised and making a finding as to the sanction to be imposed. And this should then be confirmed in writing. Again, all of these steps, so conducting the investigation, keeping an open mind, conducting a disciplinary process, and taking the appropriate sanction where necessary, are all reasonable in the context of the duty to prevent sexual harassment, and they help to demonstrate how seriously these allegations are taken by the employer, which encourages future reporting and also ensures that victims feel that there has been justice. So we've just touched on this, but it's important to consider before conducting the disciplinary hearing whether the allegations are serious enough to be gross misconduct, which could then result in dismissal without notice, even for a first offence. And employers should always consider their own disciplinary policy, which should give examples of the conduct which would be classed as gross misconduct, before then categorising this and putting the allegations to the employee. So just in summary then, employers need to remember that the duty to prevent sexual harassment is ongoing and is not simply a box ticking exercise. So it's important to keep monitoring and evaluating the steps being taken to actively prevent that sexual harassment, and especially to keep the policy under regular review to ensure that it's effective in preventing that behaviour in the workplace. This ongoing duty includes regularly undertaking risk assessments, especially if there are any changes in the workforce or new suppliers, for example, and then updating the harassment policies accordingly. It's also important to keep training managers on the policies and how to deal with any complaints raised in practice, particularly where there are new starters who may have missed the previous training on this. Identifying any trends in the complaints made and being reactive to this if that shows a pattern in a particular site or team, for example, is another important ongoing point to consider. And it will always be important to continue to develop the speak up culture with staff and to keep an open door policy and an open mind in dealing with any allegations raised. Given the higher engagement with third parties in the manufacturing sector, and therefore the increased risk of potential harassment from a third party, it's important to also carry out risk assessments to identify the specific risks in your workplace and to consider appropriate measures and steps that you can take to mitigate any such risk. So encouraging employees to report any instance of third-party harassment is also important, and being clear on how they can do this, as well as displaying zero tolerance signage in the building, will be important for those who don't actually work in the business and that therefore don't necessarily know how you operate in practice. And it's also worth including an express term in your contracts with customers, contractors, and suppliers, which notifies them of your policy on harassment and requires strict compliance with that policy when working in your business. And this is all important to ensure that you are taking reasonable steps to actively prevent sexual harassment in your workplace. And finally, offenders should always be reported to the police or to their employers as may be appropriate in the circumstances. So that brings us to the end of our seminar on manufacturing a safer workplace. Thank you for watching. We're not going to be doing a live Q&A today, but you will be sent a recording of this seminar to watch again and to share with colleagues. If you do have any queries about the steps to take for your business, or if you would like to know more about the bespoke training that we can provide, then please feel free to contact any member of our employment team. And finally, it's also just worth being aware of Myosin HR, which is our fixed fee retainer service providing unlimited advice on day-to-day employment and HR matters. And it includes a portal of templates, documents, guides, and policies which can be used to support your business. Again, if you would like to know more about this and how a retainer might benefit your business, then please feel free to contact me or any member of our employment team here at Myosin. Thank you very much.
Thank you.